website, vtsbdc.org, and that's on the Community Navigator page is where it will live. You have entered this Zoom with your camera and your microphones off. We do expect and encourage you to have questions and to ask them. So please feel free to post them at any time in the chat box at the bottom. A reminder that whatever you put in the chat is going to be seen by all participants. So keep that in mind as you go forward. So at this time, it's my pleasure to turn things over to Professor Goodenough. Thank you so much.
Thank you, Linda. Thank you very much for sponsoring this. It's a great opportunity for us. I want to mention that I will be joined by two of our student colleagues in this, Adrine Chepian and Nicholas Tonti. They are both members of our class that collaborate with the SBDC, and they will be providing some examples as we go forward. I also call out Professor Nicole Kaloran, who is the head of our incoming head of our program with the SBDC, and she will be monitoring the question flow as it comes in and deciding whether it can wait to the end or be something we come to next. The title of today is Demystifying Intellectual Property, and for many, intellectual property is an area of mystery. It's an area where there seem to be laws. What are their differences? What do they do? All of that. An hour isn't a great deal of time to cover this, but we're going to take a shot at it, and we're going to hopefully at least get an entry-level understanding of some of this. We're going to, as we go forward, have some use case examples that we will briefly explore. I'm going to look into a creative business. Adrina is going to look at it from a tech business standpoint, and Nicholas is going to look at it from a retail business standpoint. Anyway, we will provide those examples, but again, please ask questions about it from your own standpoint as we go forward. Next slide, please. The starting point for this talk is that basically there are what I call the big four in intellectual property. There's some other laws and some other things that come in, but the big four are four categories of law that cover a great deal of the intellectual property landscape, and it's what we're going to be focusing in on today. They are copyright, trademark, patent, and trade secret. And we should keep them separate in our minds and in our analysis. I tell my students when they come into their intellectual property law class that they're not allowed, they will fail on their exam if they talk about copywriting a patent or trademarking a copyright. You know, they are just that would be like saying I'm cooking my airplane. You know, just they're not the same category of things. So you need to understand that. A second framing context is the notion of offense and defense, because one of the things intellectual property can do is allow you to play offense, as it were, add value to your business, as it goes forward. And the defense is what I call avoiding the problems of infringement with others. So both it can protect yourself, but you also need to be aware of the protections that others will be engaging in, and make sure you don't trip and fall over those. So it has both of those elements to it, the offense and defense, and we'll examine those a little bit as we go forward. Second piece of this is what I sometimes call the basket idea. That in your business, part of what you are selling often is going to be some measure of intellectual property that is connected to the other aspects you're doing. If you're selling a video, if you're a video producer and you sell a video, selling that video just by itself is okay, but nobody can use it if it infringes other people's intellectual property. So part of what your job is as a business person is to put into sort of the intellectual property basket, as I call it, what you're going to want to take out and resell to others. So you need to make sure that you pull in enough rights yourself to be able to sell onward with your product or your service, your creative work, whatever it may be. A final piece of this is also to understand that there are remedies in this include the remedy often of injunction. An injunction is when a court says stop. They can shut your business down. They can shut down the business of the people that who are using your material. They can award damages, typically cash that would go to make you or the other party whole. And there's also frequently border enforcement, and that's the ability to stop infringing goods at the border. You can often use customs service to help you with that if it's coming in from outside the country. And as I mentioned, the business areas of illustration are going to be technology, creative, and retail. And my thanks to my student collaborators. Next, please. Copyright is our first subject matter. And let me point you to some resources, by the way. The copyright.gov, which is the website of the U.S. Copyright Office, has a lot of material on it. In each of these cases, I'm going to alert you to official or other government websites where I can. There's plenty of other outside material as well, but the copyright.gov is a great starting point if you've got further questions. Now, what is covered by copyright? Again, I've said these are different categories, and the entry point for the categories is what they are covering. And in this context, we see that the coverage is original works of authorship fixed in a tangible medium of expression. That's the statutory language. And essentially, if you have a creative work of authorship, which can be a book, it can be prose, it can be writing, it can be audio-visual, it can be a video, it can be music, it can be a recording or a composition, it can be a work of fine art, it can be a sculpture, it can even be a work of architecture. These are things that are protectable under this statute that fall into that category of works of authorship. It can even include, to some degree, a computer program. A computer program has enough authorship in it that it gets some protection. Although there's a distinction that's made between the creative content and the ideas. It's called the idea expression dichotomy. And we can take the ideas from a copyrighted work. We just can't take the way they did it. So in a computer program, that would mean that you can take the functionality, but you can't take the exact way they did it. You can also take, say, the facts out of a history or other kind of factual content that is related to the idea rather than to the creative expression. So that's what the category is this works of authorship, creative works of authorship fixed in a tangible medium of expression. There's also automatic coverage. Since the 1976 Act, the old requirements that in order to have coverage, you needed to file and you needed to put the notice on. Filing and putting the notice on are useful, as we're going to see in a moment. But the current law says that when on creation, there is an automatic level of protection for copyright. The formalities you'd be used to, they are useful. They give you a little extra in the way of damages, and they're useful to do. Keep in mind of that. There's the notice one, which is the copyright symbol, author, and date. You're used to seeing that on works. And registration, which can go down to you put it on, you register your material with the Library of Congress. And again, that gives you extra rights in a litigation or something. Good idea to do if you're serious about your protection. But neither of them are make or break requirements. What is the time frame? The coverage is a life of the author. If there's more than one, the last to die, plus 70 years. Or if it's a corporate work, a work for hire, something like that, it can be for 95 years.
And we had a question about that in the chat, Professor Goodenough. Keith Epstein asks, what are the reasons for extending copyright so long after death? The length of time seems extreme when compared to patents.
And the answer to that is yes, it does. And the best answer I have for you is Mickey Mouse. Each time Mickey Mouse has been about to go out of copyright, the Disney Corporation has engaged in an intensive lobbying effort to make sure it doesn't. And it has twice extended that now out to 70 plus and 95. 100 years ago, it was a much shorter time frame. There we go. It's not just the Disney Corporation, but they have been the leaders in that lobbying effort to extend the protection of things that exist. Go talk to your member of Congress. They have done that twice. Mickey Mouse is probably going to go out of copyright again in about 5 years. I don't know whether it'll get extended again or not under the circumstances. You say it's pretty far out there already. Anyway, there we go. It's these laws are a matter of a combination of lobbying from people wanting protection and lobbying from people not wanting protection, wanting free access, and what we see is a classic legislative compromise. Excellent question. Sort of cynical answer. There we are. Moving forward. Next slide. The rights for the copyright holder are set out in Section 106, principally of the Copyright Act. Basically, the copyright holder gets to control the creation of copies and their sale or distribution, and that includes web distribution. So it includes all of that. They get the right to public performance and display, which includes broadcasts, web distribution of music and videos. They get to control derivative works. These are knockoffs. All of the Harry Potter novels, except the first one, are derivative works of the first one, but the copyright owner of the first one controls those derivative works going forward. And there are also some special rules on music, radio, and streaming. The Copyright Act has a bunch of very technical special rules around some of uses of media, some uses of music. Again, not a time to go into them now, but if you're in those businesses, just be aware that you're going to have some complexity around that. So offense, our use cases. Let me start with creative work, which is my piece, because that's obviously copyright is very important in a creative business. If you are a design business or a fine artist or creating videos, these copyrights are going to be very important. I remind you of that notion of the basket. Make sure you collect the rights from everybody who's connected with the project so you can sell it on out. So you make sure you get those rights from your employees, contractors, etc. Adrienne, do you have a thought or two on a copyright in a tech business?
Yeah, so copyrights in tech business are important, are really important, because if, let's say, as a tech company, you have a software or you're using a software that you've created, the actual code in that could be copyrighted. Now, which means that no one can improperly use your work for their own benefits. Another is if you even make instruction manuals for the software or this thing that you've created, that's copyrighted because it's your own work, your own illustrations, and that protects your work from getting taken and used essentially for free in a competitive company. I could, if I were doing that, I could register it for copyright protection, but I wouldn't need to register it. So it's important to protect the work that you're creating within your own company so that it doesn't get used with competitors.
Great, thank you, Adrienne. Nicholas, in your retail business, how would you envision a retail business as having an offensive use, a ability to protect their own work?
Right. So for retail, I used a business that's easy to conceptualize, and that's a pop stand. So in a popsicle stand, right, there's a vendor who sells popsicles, where they can use a copyright law is in instances where they produce for example, a brochure or some type of photo of their popsicles. Or for example, let's say this popsicle stand creates the periodic table of popsicles. Assuming nobody's copyrighted that or made that before, that's something that is unique and copyrightable for something like retail. And that for offenses, that's what a retail business.
So as we see, the creative business is particularly important for a copyright, but even in a technical business or a retail business, whether it's the content of a brochure, of an advertisement, a photo of the product, a website of some kind, it can be very important to keep track of your copyrights as you go forward. On the defensive side, again, one of the key elements is to make sure in a creative business that you have the clearance, as it's sometimes called, that you have all of those rights into your basket that you're going to need to keep selling it out. And those clearances can be quite specific with respect to a particular production or something, or they can be general. Sometimes people businesses have in their employment agreements have assignment of intellectual property rights clauses that go in. Those can be very important in a creative business in particular. There's also fair use. We should remember that fair use, not every use of a copyrighted work is prohibited. There are fair uses in things like news or in short quotation and things like that will permit you to use. But you always want to know what it is that you're relying on when you use somebody else's work. Any caution to your tech folks?
I'd say that the only defense is the same as offense. The same way you don't want people using your copyrighted material, don't use other people's copyright material, especially if you know that it's copyrighted. One of the ways to just kind of make sure or just double check your work is to look at the US Copyright Office. Search up copyrights, see if anything similar exists, and at least that way you can provide yourself with a little bit of protection that you're not gonna deal with some issues at the end of using those materials.
And tech companies often rely on open source material because, you know, a fair bit of code is open source and available. Check those licenses and make sure. Sometimes the open source licenses let you do commercials. Sometimes they don't. Sometimes they require you to sign on. Make sure you're just paying attention to the terms of those things if you're in a tech business. Nicholas, how about your pop stand, the popsicle stand? What is it going to be thinking about in terms of making sure it doesn't infringe on others?
Right. So in that example, maybe the popsicle stand would try to avoid copying other photos of popsicles, or without getting the clearance, either posted on their website or put on a cart. Same thing with maybe written descriptions of certain things. That.
And again, that's a trap that sometimes companies fall into. They see that perfect popsicle photo and they online they say, well, I'll just copy and paste. Technically copy and paste is easy, but from a legal standpoint, copy and paste might get you in trouble. There are frequently pre-cleared images. There are services that do pre-cleared images and things like that. That's a great way to find things for yourself. Just pay attention to the fact that don't take those shortcuts if you can avoid it. Okay, any questions that we should be popping to now, Nicole?
None in the chat, but I had one of my own. Can you give us an example of what might be fair use in some of these settings?
Fair use. There's a very complex set of standards around fair use, but they really simplify down to the notion that in kind of news work or in education or in reviews or in criticism, it is frequently possible to use excerpts from a copyrighted work. If I'm going to critique a book, I need to be able to quote the book to critique it. I can't quote it so extensively that I'm basically substituting the book. I can't say, I want to critique this book. Let me just give you the whole thing because you need that. That wouldn't work. But a half a page, a paragraph, something like that, if it's appropriate, that becomes possible. So again, it's that kind of use that would be privileged in this context. While I'm mentioning it, I should say sometimes people think that nonprofit uses are exempt, and that's not true. The nonprofit gets a little bit of extra help on fair use, but a public nonprofit performance is subject to copyright. The distinctions are private and public, not for-profit, nonprofit on most of these uses. Okay, trademarks. Whew. Let's shift gears and shift categories, shift bins. Trademarks are, first of all, the resources there. There's the U.S. Patent and Trademark Office, uspto.gov. By the way, patent is, unlike copyright, which is basically all federal law, there's some state law on trademark. We're not going to spend much time on it, but you should be aware it's there. What is its coverage and purpose? It covers designations of origin of goods and services. Who, what company, what people, what is the source of this, and we set it up with some kind of identifying mark, either a word or a picture or some a symbol, something that will associate, that will tell people when they're going out to buy this that that's what they're buying. In the soup line, Campbell's Soup, the name Campbell's Soup is a trademark of the Campbell Soup Company, because if you're going to go out and buy soup, when you buy Campbell's, you expect to get a certain quality of soup in that can that is associated in your mind with the Campbell Soup Company. So again, it can also work with services. The core standard here we have is that we need to avoid the likelihood of confusion. If I call my lecture here the Coca-Cola lecture, you're going to think that it has an association with a soft drink company in Atlanta, probably. that would create confusion about what the source of it is because they're not sponsoring this lecture. Again, it's that kind of identification that you can rely on as a customer, and that the brand can build goodwill around, build value around. That's what is protected in this context here. There's various levels of protectability, and it has to some degree to do with the nature of what you're showing and what you're claiming as a mark. Generic marks have no protection. If I'm selling fruit and I say, this is apple fruit, I can't claim any protection of that. Why? Because that's what we call it. That's the generic name. So the names of things can't be trademarked because they would take out of commerce the very name we use to speak of them. Descriptive marks can sometimes be. Descriptive is one step up on generic. That's where we have an added description like really good apples. So we've added some words and all the rest of it, but it's not distinctive really. It just is a further description. But with enough time and enough use, sometimes that descriptive mark can gain some protection. What we know can be is something that is suggestive, which is an okay. Yeah, again, this is a step up on descriptive. A suggestive, which is for instance, there's a kind of cheese called Good cheese, and Good is all one word, and essentially it's really a kind of a descriptive, but you've changed it enough to make it kind of suggestive and not just descriptive, or again some kind of weird adjective applied to apples. Athletic apples wouldn't be a normal description, it would be suggestive. So I might be able to get a mark in athletic apples. Arbitrary gets good. Arbitrary is things like the use of apple to describe not a fruit, but a computer. And so Apple computers can be trademarked because Apple in that context is arbitrary. And the best of all is things that are fanciful, and these are words that don't exist otherwise. One of the famous ones of this is the oil company Exxon, 2 X's and Exxon. Think about the trade names of most pharmaceuticals, Squirclax and Squigscux, things like that. High Scrabble value letters often give you these kinds of fanciful names. So those are typically good, provided nobody else is using them. And nobody else is using them, particularly in your line of commerce. Sometimes you can use an exact one that other people are using if it's in a different enough line of commerce that there wouldn't be a likelihood of confusion. Again, that's sort of the levels of protectability. I should mention there are registered and unregistered marks. Unfair competition and passing off with the letter TM says I'm claiming trademark, but it doesn't meet the standard for registration, which is what we've just been looking at about, basically. It doesn't quite get, it's descriptive, doesn't get there, but I'm still claiming it, and people should be aware that even though I can't register it, that I'm setting that up as something that would be confusing. So if you see TM, that means a company is saying, this is my, this is one of my identifiers. I haven't registered it yet. Maybe I can't, maybe I could, but just haven't, but I'm putting the world on notice. That gives you some protection. Then there's the protection of registration, and there's state registry as well as federal, but federal is the key one because it gives you nationwide protection. If it's registered, if you successfully registered it, you get that R in a circle, or if it's a service mark, the S in a circle, no time limit on use. No time limit on use. Unlike the other intellectual properties, patent and copyright, where there's a time limit. Here, provided if you are keeping it in use and active, you can keep that mark for as long as at least the current statutes exist. Okay, next, please.
We've got a question in the chat that I'd like to pose because this comes up a lot in our educational consults too. Deborah asks, we have many value-added food businesses. Can you comment on the recipe versus the trademark? This is often very confusing.
Aha. The recipe would be something that might have some patent, probably doesn't, for reasons we'll talk in a moment. The specific statement of the recipe could have copyright protection, but because the core of the recipe is an idea, a method, that kind of thing, that method and idea doesn't get copyright protection. The illustrations that go with it, the actual phrasing, if you turned it into a song, the song would have copyright protection. That'd be cool. But the method, the cookbook method is not copyrightable. Trademark would not really apply in this context, because trademark would be if your recipe company, was called Mariana's Trench. I'm trying to think of something that's really out there. The Mariana's Trench apple cider company. Mariana's Trench would be potentially registerable as a trademark. But the recipe for making any of that stuff underneath would be unrelated to the trademark itself. And Keith Epstein, I see, is asking that if Mickey Mouse expires, then copyright, then someone else can make a movie with the character. And the answer is yes, although they couldn't borrow on the character as developed in later, still under copyright cartoons. The original Steamboat Willie, which I believe was the original Mickey Mouse cartoon, would go out of copyright. You could make a derivative work based only on Mickey Mouse as he appeared in Steamboat Willie. So again, you can't. You've got this kind of rolling copyrightability in the later works that hasn't gone out yet, but as they go out, then yes, it enters what's called the public domain and becomes fair game for that. One of the reasons why you see a lot of Jane Austen knockoff novels, what is it, Pride, Prejudice, and Zombies, or whatever it is, there's some weird ones out there, is because Jane Austen is out of copyright, and you can now create derivative works and do all that kind of thing around Jane Austen. You cannot do that around the works of a more contemporary romance author.
Could I ask a clarifying question on the value-added food businesses? Because I think this comes up often too. Can companies protect a particular kind of cheese or a brew or a particular kind of product under trademark?
Under trademark, the product itself, no. The identifier with the product, yes. So in other words, I'm rather fond at the moment of the Brave Little State beer, which has been done in conjunction with VPR. That the formula of that beer, unless it's covered by trade secret or patent, is not protectable. It's not protectable under trademark. Trademark gives you no protection for the formula. It would give you protection against people than other people being Brave Little State with their brand of beer. Okay. Again, that's a nice example of this kind of confusion that people get of is it, can I trademark a formula? And the answer is no, because trademarks are the origins of goods and services. Formulas are either patents or trade secrets, and to some degree copyright if it's just the formula, the particular way the formula is stated. So next page. Registration process. Find something distinctive enough to register. Again, as I mentioned, it's a little hard. There's so many the trademarks registered. I've been working with a business myself, and we've been struggling to find trademarks. We say, oh, wouldn't it be great to call it X? And it turns out somebody else called it X. So you need to do that, and doing it yourself can be okay, but an expert help can be quite useful here. Various lines of commerce, etc. There's some modestly tricky pieces here. Online help can sometimes help you get through that. Things like LegalZoom and other online help companies can sometimes fill that in. But again, DIY is not a great solution here, and a lawyer can be helpful. Also, in addition to lawyers, there's sometimes trademark assistance services, which may have a lawyer attached. They can sometimes be less expensive than hiring a lawyer outright. And remember that your URL, your website name and corporate names need clearing too. What are the rights of the holders? We've seen injunction, damages, stopping at the border, the normal stuff. And then offense and use cases. Before finding a usable mark, which is harder and harder, don't fall in love with it. Don't fall in love with your idea. Oh, it would be so wonderful. I live in Woodstock, to be able to call my cider Woodstock cider. Wouldn't that be just perfect? Well, the problem is there's probably somebody out there already calling something Woodstock cider or Woodstock foods in ways that would go. So don't fall in love with it before finding out. You can do searches on the US Patent and Trademark Office. They have a search. Google it. World's cheapest search. Just Google it. See whether somebody else is using it. Check on the URL and domain name. Don't fall in love with it if somebody's got the domain name. Okay, cool, but I don't. And make sure you get rights to designs as you go forward, and enforce it as you go forward. Nicholas, trademark and your popsicle stand. Nicholas, are you there? Are you? Nicholas has been having some computer difficulties.
Yep.
Nicholas, we're not hearing you on your.
Can you hear me?
Yes, now we do.
You might want to turn your camera on,
Yeah.
Nicholas.
Trademark can be useful. This vendor sells the best pops. Sorry.
Nicholas, we're not coming through. But I'm gonna channel my inner Nicholas and suggest that I think what he's saying is basically that a popsicle stand could very easily find trademark quite useful, identifying their brand. Again, particularly if they're distinctive in some way. That this is a place where many kinds of businesses can find value adds. Adonai, in your tech business.
Tech business, the things that you can trademark are names, phrases, logos, any symbols. So let's say my name, or I want it to be, is Nova Software Solutions. First look if that's available. If it is, it's eligible for trademark. And let's say I want to use a phrase just the same way Nike says, just do it, or McDonald's says, I'm loving it. These are trademarked phrases. So I can, if it's available, trademark the phrase like your custom tailored software solutions start here. I can trademark that, and if I'm using it as commercially in my business, that can become a trademarked phrase with the eligible protections.
And the thing I would point out in that context is that the trademarking may have to be TM because the registration involved may be difficult for a phrase like that if it's too descriptive. So again, you may want to put TM after it, and often you'll see the companies do TM. And when we talk about trademarking something, we're talking both about that TM as well as the registered piece. On a creative business, again, actually titles of books and things aren't trademarkable. But series are. So Star Wars is a trademark. The name of any Star Wars movie or book is not. So it's an interesting piece for creative businesses. Obviously, if you have a studio or something like that, you want to have a name of, that could be a trademark circumstance. On defense. Again, you want to avoid other folks. Nicholas, are you without your picture? Are you audio there? Oh dear, Nicholas,
turn my video off. See if that's a better connection here.
That's a little better. It's still bouncing around. Give it one more try, and otherwise I'll have to channel you.
Okay. How about?
No, you're just not working. I apologize, Nick. We're gonna need to just channel you here for a little bit, I think. So in a retail business, obviously trademark can be quite important, as we mentioned earlier. That the popsicle name brand, that's what a brand is in that kind of thing. And so in a retail business, both the brand of the store or the website or other or of the restaurant, whatever it may be, and the brands of the particular items being sold can be well worth doing that. Ben and Jerry's ice cream, for instance, has made a bit of a thing out of having funky names for their different things, and so that then Breyers does not sell Chunky Monkey. That's something that Ben and Jerry's got. So again, keep in mind all of those pieces. And then on defense, again, you don't want to, if you're a food company like that or another retail company, you need to be careful about using other people's brands. You are permitted to use the brand of something you're selling legitimately in connection with that sale. You are permitted to say, hey, I'm selling Sony electronics, but you can't say Sony. You can't call yourself Sony just because you're selling Sony electronics. So again, you have to make the use proportionate to what your actual legitimate activity would be. Adonai, do you have a concern, a defensive concern for your tech company?
Same as copyright, don't use other people's trademark material in your company. Go on the uspto.gov website, search trademarks, do the best that you can to make sure that what you've created for yourself is actually created out of your own brain. And that'll give you offensive and defensive protection. So just to make sure that you're covering all grounds before you use something as your own.
Exactly. I mean, it'd be so convenient to call my company Coca-Cola Company, right? But Coca-Cola's got the rights to that, and they're not going to be pleased with it. So again, just be very careful about what you do. Make sure your uses are okay, and avoid accidental and intentional infringement. Next slide, please.
We actually have a question that I think is
Okay.
pertinent here because it asks about timing to protect intellectual property. Deborah asks, this is a typical situation that a business will not consider all of the complexities of IP, and then as they grow, it can become problematic. Is there a best time in a business, or are there very specific types of businesses that should always consider a consult with an IP lawyer to make sure that they're doing the right things at the right time? Great question.
Well, obviously, an IP lawyer is likely to be your best way to buy some protection, but it's also not typically not cheap. Sometimes you can bargain with a lawyer or find services that can help. One of the nice things about the Navigator service that we're part of here is that there are the possibilities, at any rate, for small businesses that qualify within its framework to get some subsidized legal help, and that can be useful here. Right at the beginning, particularly on this trademark one, where folks are getting, picking a name, gee, wouldn't it be nice to call ourselves Woodstock Cider? Yeah, cool. It's right. Well, they should just check it out. Make sure that it's okay. The do-it-yourself stuff is available to some degree here, and they should check on this. Again, the copyright piece, you can, just don't click download and paste that really good photo you want that comes off of somebody else's copyrighted work. Patent we're going to come to in just a moment. Patent is full of patent is the most complex of this, and we're going to come to that in a moment. We see the trade secrets, set it up right from the beginning to keep your secret secret by having good employment agreements, good consulting agreements, that kind of thing. How can people contact your organization for assistance? Nicole, or I don't know whether SBDC. Well, let's hold that one, and because at the end we'll give a couple minutes for the SBDC to do their bit of advertisement. Okay. Great. Next slide. Patent resources, again, the US Patent and Trademark Office.gov, uspto.gov will get you to their website, and they have good resources there. Coverage and purpose. The coverage of the patents is basically inventions. Copyright, creative works. Trademark, identifiers of goods and origin of goods and services. Patent, inventions. And patent gives exploitation rights to folks who are inventors of truly qualifying stuff, truly new inventions, the right to control it, typically for 20 years. That which is not as long as copyright, but still a decent amount of time. What is its coverage? Must be, there are 4 categories that are mentioned. One is a machine, a manufacturer, a composition of matter. What composition of matter? Molecules, alloys, but typically molecules. This is big for the drug companies. Or a method or process, a way of doing stuff. And an invention can involve more than one of them, and might involve one but not another. One of my favorite disaster stories in this was the inventors of Botox used botulism toxin to inject in wrinkles and freeze out the wrinkle and make you look younger. Really cool method. They went to a lawyer. They were Canadians. They went to a bad lawyer in Canada who said, "Oh, it's a naturally occurring substance, and therefore you can't patent it," which is true. However, the novel method use of a naturally occurring substance may be patentable. So anyway, there we go. The Botox people lost out. In order to be patentable, that invention must be novel, useful, and non-obvious. What do those means? Novel means that it hasn't been done publicly, basically, before. That invention or some near equivalent hasn't actually been publicized, published, put to use, sold, demonstrated, put out in the public in some fashion by somebody else, or even by yourself. We'll come back to that in a moment. Useful is easy. You're not going to bother with it if it's not useful. Non-obvious is a little bit of a step further, which is to say we'll only grant patent to stuff. It may be brand new, not novel. It may be novel, not anticipated. But if it was something that anybody reasonably skilled in the art would have just come up with, if you pose the problem, then that's when it's obvious. It has to have that extra step of some kind of inventiveness that goes beyond that which anybody normally skilled in the art would do. By the way, one of the reasons why recipes are hard to patent is because they're mostly not novel. And if they are novel, they may well be obvious, i.e., hey, I want to do Japanese Cuban fusion. Well, you take the list of ingredients on Japanese food and the list of ingredients on Cuban food, and you kind of put them together, right? I mean, a reasonably skilled cook, a chef could probably do that if they thought about it and decided to. So again, that's hard to have foodstuffs that are patentable. Now, self-revelation. I said in a novel that one of the things you could do would be to be you as the inventor putting it out there. There's often a 1 year kind of grace period after you blabbed it or sold it or whatever you did. You can get up to a year to file if you are the actual inventor. If you're not the actual inventor, then then when the inventor blabs, that shuts everybody else out. But the inventor gets that 1 year grace period. It's only 1 year and you have to be quick about it. And so one of the lessons is for patenting stuff, get in there early. Get the patent decision made before you're publishing, before you're selling, before you're offering, because then the clock starts to run and you're just out of luck. My uncle, I'm going to brag on my uncle. I apologize. Let me brag on my uncle. My uncle was one of the co-inventors of the lithium battery. He was a professor at Oxford at the time, and he just kind of published it. He published it, and the British government at that point, didn't. And there we go. Sony got it, and Sony commercialized it, and my uncle, at least from that, received no royalties ever. He did get the Nobel Prize. There we go. It's not so bad. Anyway, thank you. I apologize for bringing family in every now and again. You got it. But again, you have to do that quickly, early, get it done. It's one of the things you want to do. Not laws of nature and natural substances. They are off the table for this. And the process is quite complex. It often has an application. It's involved. This is where you need a lawyer, because the application, unlike copyright, which takes care of itself, or trademark that maybe you can do, this one, there are people who self-patent. They are rare breed. They do exist. Maybe you're one of them. But this is an area where you probably want legal help because it's needed. Also, it's fairly expensive, sadly. The patenting process isn't cheap. Next slide. What are the rights? You get a 20-year monopoly, we mentioned, but only in places where the patent is obtained. Internationally, basically, you have to file in every country that you want to have a patent in. So if it's something that wants international patenting, again, that's added expense and time. There are some shortcuts on the filing you can do, but essentially you have to figure out, what are the 10 countries that really matter and go for it. Unless you're Coca-Cola or some other, well, Coca-Cola doesn't patent, but General Motors or General Electric, or you're patenting wildly, they will do a lot of countries, but basically you need to figure out your strategy and what you can afford and where coverage is important. Again, rights of the holder, injunction, damages, border exclusion, all of our normal good list. Offense. When we're using this on offense, it can be help greatly solidify a business line against competition and allow profitable licensing. It's cool. But in my creative, very little is likely to be patentable in my creative company. If I come up with some brand new way of editing digital video, maybe that could be, but most of what I do is going to fall into that creative list, and that's going to be a copyright, trademark kind of thing, and not so much patent. Adonai, you're by contrast, I think, going to have a fair bit of patent in your technological company.
Not to a certain degree, because if it's a technology company, if it's either a machine, a manufacturer, composition of matter, essentially, if let's say I have an algorithm that solves something in a very unconventional way that could be patentable, but other than that, unless it's something that really just works together to be a brand new, unconventional way of doing something, it's not patentable.
Edna is right, and I was actually wrong to suggest it was as strong as I was with her company. Tech companies actually fall into this interesting piece because software algorithms themselves, to the extent they're just mathematical, have been held to be non-patentable because they are laws of nature. But if they help you do something, it might be patentable. So if they are a new way of doing a method, if you can tie it into a method or a key element in a machine of some kind, you may well be able to patent it in that kind of context. If your company was more of a manufacturing company and less of a tech company, maybe you'd have a little broader patentability for machines or the new widget that you. Nick, are you? Let's try your sound. How are you doing?
Is this better?
Is it better? Yes.
Okay. So retail again, maybe is one of those areas where there's patents may not be used too often. However, we bring it back to the popsicle stand. If the popsicle owner created something that a popsicle stick that kept the popsicles from melting or something like that, that would be something that could be patented on the retail side.
Exactly. The retail piece, again, if you have a method or a machine or some new breakthrough that really would qualify for patent, always worth having in the back of your mind for your business, because if it is patentable, it can be a very useful piece. But again, who's going to be able to exploit patent is going to be more chemical, more to some degree the tech folks, but certainly the manufacturing folks. That's where a bunch of this will come. And on defense, I'm just going to summarize again for all of us: avoid infringement. As Adonai keeps telling us, don't use other people's patents. Be aware that they exist. Do the research in the patent office. The patent office allows you to research every patent that's been granted and many that have been applied for. And they're online. They're a little tricky to find and sort through, but you can do it, and it's well worth it. By the way, that can also provide useful ideas as well. I didn't know you could do that. It's at least a way of doing that. So a piece of your homework for your business. Any questions before we move on to the next?
Yeah, we have a question. What does patent pending mean? Sarah's asking. Is there any protection from that?
Good for you. Patent pending, very little actual protection, but a lot of prospective protection. What that means is that they've filed a patent. Filing a patent is no guarantee of getting the patent actually granted. I have filed one patent in my life and it was not granted. There we are. What can I say? But patent pending allows you to put a label on the thing that you're manufacturing, selling, etc., saying it's like a warning, saying I put in a claim for this. I don't have it yet. Any day the patent office may give me the rights. You want to set up a production line and manufacture? Cool. Just wait. I'm gonna get you. So it's kind of a warning. It's a little bit like beware of the dog on your front lawn. It's meant to warn people off. Not yet. The dog isn't outside. Might be. So it's a warning that way, and it may give you. There's some little bits and pieces of rights that may come with it in the meantime, but basically the patent pending. The big thing is that it tells people, we're working on this. Don't get invested. Okay, great. Next, our final category, and we're nearly on time. Our final category is trade secret, and trade secret is quite interesting. It is not. It is typically a state law. There's no federal law. I can refer you to this National Review article. Gives a nice background on it if you're looking for additional information. Coverage and purpose. It covers protect profitable secrets. It covers a secret. It doesn't cover the thing itself. It doesn't protect the information itself. It protects rather the owner of that information, if they're working to keep it secret, against illegal spying or illegal disclosures. The element of protection is that it must be a valuable secret. The owner must take reasonable precautions to protect it. So it must be valuable, it must be secret, and the owner has to take reasonable precautions to protect it. If the owner is doing those things, then they can sue if other people use improper means of figuring this out. What are improper means? So we've got a definition here: theft, bribery, misrepresentation, breach or inducement of breach of duty to maintain secrecy, or espionage through electronic or other means. It's basically industrial espionage or corrupting someone with a duty not to disclose are the two big things. Next page. And the precautions, what do? You have to keep it secret. Precautions include physical security. Keep the drawings in a locked file cabinet under lock and key. Keep the secret under lock and key physically. Have good cybersecurity. Take cybersecurity methods, and have non-disclosure agreements, confidentiality agreements with those with access, so that you cover that. Your employees in your employee agreement, in addition to an assignment of intellectual property rights, which we talked about above, right? You also want to have a very, confidentiality provision in those. Do that with your vendors, do that with your contractors, do it basically with any person or company with access. One of the reasons you see as much NDA getting scattered around in business relationships is it's one of the elements that lets you maintain these trade secrets. And if you have it, keep it secret, do all those things, and somebody steals it, there we are. But what are your rights? No time limit. Coca-Cola patented their famous formula back in 1900 or whenever it was, or 1895. It would have expired, decades ago. As it is, they still have these rights in it because it's a trade secret. It is not a defense against reverse engineering or independent discovery, because those are not espionage or corrupting somebody. You go out and buy a Coca-Cola, you can try and reverse engineer it all you want. That's not this espionage stuff. What you can't do is bribe the secretary in the Coca-Cola headquarters to make a quick copy of it. A secretary in the headquarters did some decades ago do exactly that. Tried to sell it to Pepsi. Pepsi basically narked them out, basically ratted them out and told Coca-Cola, and the poor person was fired and went to jail and all that. There we go. Offense and use and use cases. It's not, by the way, it's not just technology, it's customer lists, other valuable private information, and businesses. So for instance, my creative business, if they had a customer list of some kind, that could be a trade secret. But only if I take the precautions. Again, we want to make sure you take the precautions you have to for physical, cyber, and confidentiality protection. Adine, do you have how's your tech company doing with trade secret?
They care about it a lot. Because let's say in a tech company, you have a software and whatever, and like a little widget comes out of it, like a little electronic device. Things that can be protected within the company as a trade secret are customer lists, wholesaler lists, manufacturer lists. So anything like manufacturers that have helped put this together, or wholesalers that have given us little pieces of this. The processes could be trade secret, but you have to take those steps necessary to maintain it as a trade secret. So if you maintain as a trade secret your wholesaler, but if somebody were to take apart that little widget and there's the name of the wholesaler company on one of the pieces, that's reverse engineering and it's not protected. So just because they don't have a list of your wholesalers and then they got that information doesn't mean they violated trade secret. So just make sure that you're covering your tracks as much as you can to maintain it as a secret.
Great. Nicholas, what about your pop stand?
Yes, so trade secrets can be used in the popsicle stand and retail business. So for example, similar to the Coca-Cola example, if you have a very, very unique recipe for your popsicles, that's something that can be kept as a trade secret. If you have a novel sale and distribution method, this popsicle stand has the most unique sale and distribution method of distributing their popsicles. And similarly, they could do their business plan as a trade secret. So again, along with all of the limit the things that the business owner has to do, they can be used. The trade secrets can be used.
Great. So yes, as pointed out, recipes, now the trade secret piece can apply to recipes provided you keep the recipes secret. Again, if you publish these things and then they stop being trade secret, they have to be kept secret to have this kind of protection. On the defensive use, again, behave yourself. Don't take other people's stuff wrongfully, and be careful with new hires. New hires are often a place where they come over with some trade secrets from their competitor. You can't really use them. The new hire may well have signed a non-disclosure agreement that has application after they've left. You should be aware of that. There was a case a few years ago where I think forgetting who hired away from Google one of the self-driving car folks, and self-driving car person arrived with a briefcase full of things, which were trade secrets, and a very, very widely publicized case. I think President Trump ended up pardoning him for reasons that were obscure. That reminds me, by the way, that it's not just new hires, but on a defensive, one of the things you also need to do is be very careful about when you fire people, because when you let people go, that's when they're mad and then they download everything. Or when they're planning to quit, that's when they download everything. So you just need to be careful about that, and that's one of the reasons for the somewhat inhumane, come in and you're told you're fired, you go back and your computer's locked and your desk has been cleaned out, because people are trying to make sure that you don't walk off with the company's trade secrets. It's not a humane way to go, but it may be a legally effective way to go. Are there, I think that then wraps us up. I'd take questions on trade secret, general questions, but also want to keep a minute or two for SBDC to say we're nearly out of time, but not quite. Linda, what is your preference here?
Sure. Thank you. Certainly, we have time for a couple more questions. Thank you, Professor Goodenough, and contributions from students. I really think it added to the conversation having this offense and defense pieces included. So we're happy to take a couple more questions. I see.
Well, one of the questions that I have you is there are people who wanted to know how could they connect in with the Navigator program?
Sure.
Yes, and I'm going to put that address in the chat here. Anyone who's interested is are welcome to sign up. We start with a free legal educational consult and go from there. We have access to some paid legal services as well for qualifying businesses. And then we had a question in the chat about customer testimonials, which I think is a great one. Deborah says, I had a question from a client the other day and I'm not sure it is relevant here. She'll ask it anyway. A customer gives a testimonial. Can it be used on social media or in other media without their express permission? Essentially, once they give you the testimonial voluntarily, do you own it?
A good question, and it's one where the answer is not fully clear. On one level, you are allowed to make factual statements about stuff, but on another level, you may not always, the use of someone's trade name in connection with advertising, etc., comes under a slightly different law. This is not one of the big four I mentioned, but a different one, which is the rights of privacy and publicity. And people have a kind of almost trademark-like protection of their own name. And so if you start to appropriate their name and their identity in a way to show an endorsement, that's sometimes actionable. Now, countervailing that is kind of First Amendment right to say things that are true. And if this person said this nice stuff about you and it's true, cool. But you use of their name and their testimonial without their name, without their permission, is a way also to create someone who's mad, who was a good client who's now mad at you, and you don't want that. So the best practice is to really try and make sure that you get people's permission. They'll often be thrilled, but if they're not, okay, too bad. It would be nice to be able to mention that. What you could perhaps do in that is have just customers have said, and then put quotes around it, and then do that without saying who that person was. That's an in-between way that might work.
There you go. Another question from Sarah. You said that the patent process is expensive. Can you give us some idea of what expensive means?
Expensive means it's going to be hard to get good legal representation for the US for a simple patent thing for much less than 10 grand. And it can be a couple of multiples of that. My own patent process, I think, ended up costing about 20 grand and again got turned down. So there we go. Luckily, I had business partners who were covering some of that cost. So it was, there we go. We didn't get coverage. There we are. We took a bet we didn't get.
That is expensive.
Yeah.
I don't have any other questions in the chat. Does anybody else have any that they wanted to unmute and ask before we let you go?
So I
Great,
will
Libby.
just,
You
yes,
wrap up.
I will cover that. Again, thank you so much. We really appreciate our partnership with the Vermont Law School, both our interaction with the faculty and the students. We've learned so much from them. Our team of advisors has, and we know the business owner community has. So we thank you for that. We're so glad that you're a part of the 9-partner community navigator program. And so thank you, Professor Killeran, for putting that in the chat on how to connect directly with the law school. So you'll see on this slide, if you have general business questions, certainly would encourage you to reach out to Vermont Small Business Development Center. You can do that through sending an email here to sbdc@btsbdc.org. Also, the links to the recording as well as the slide deck are going to be sent as an email to all people who registered for this webinar today. So everyone will get a copy of this. And shortly, probably within the next several days or next week, we will have the recording placed on our website and we will be promoting it via our social media. So that's a plug for you to follow us on social media. And again, thank you for attending. We really appreciate the great information that was shared with everyone. So thank you again and have a great day.
Thanks, everyone.